still have such an effect on these trials?
There are no trials. I don't know what you're referring to. There's been only one trial that we're aware of.
So these are congressional, I mean...
The RIAA, as I mentioned, their typical scenario is to discontinue the case before the trial. You want to finish up?
Right. I guess I'm going to speak for a little bit longer than I intended, but Ray wants me not to speak as much. But this guy is Dr. Powels. He's a assistant professor of Delft University of Technology in the Netherlands. And basically, he's one of the experts that we relied upon to discredit Dr. Jacobson. And he calls Jacobson basically borderline incompetent, which I would have to agree with, because some of his, his methods, Dr. Jacobson's methods are untested, they're unpublished, they're his own making, and he doesn't even follow proper scientific procedure. This is a printout from the Encase Forensics website. This is one of the main tools used by consultants in the law field who do hard drive forensics. And as you can see on number 4 here, it says document findings. That is what you have to do when you do any kind of scientific inquiry. The scientific method you might have learned in elementary school, how to devise an experiment, to, you record your procedures, you document everything so that other people can verify what you've done for accuracy, and they can reproduce the results to either confirm what you found or to refute your findings. So, what Dr. Jacobson, when we asked if he produced any kind of documents, let's see what he says. Let's see, in case. I'm sorry, okay, let me find here. Okay, here we go. Did you generate any reports, is what Ray asked him. He says no. Now, I'm not asking if you printed out reports or saved reports. I'm asking if you generated reports. He says no. Now, how do you do forensics without generating reports? I don't know what he was looking at. So he says, we didn't find anything, so there's nothing to document. So let's see, I examined the hard drive, here we go. I examined the hard drive, found no evidence of file sharing software or audio files, so there was nothing to document. So basically, we have no idea what he did, what kind of procedure he followed, what kind of investigation he conducted, but there's no scientific basis for any of his stuff. He's just, I don't even know if he even looked at the hard drive, frankly. So that's the kind of science he kind of spouts. This is a printout from a elementary school in Tennessee. Okay, number 4. Write your procedures. Tell what you did. Write down everything. List each thing that you do, number each step in order. Write down everything you do. Others should be able to repeat your experiment by reading your procedures. Okay, this is something that they teach to 10-year-olds. So he's Jacobson's basically he's just sort of a quack. I'll wrap up in a bit and open up the floor to questions, but let me just pull up a few more other things, some of the wackiness that he says. So in all these cases, the RIAA says that the defendant did not have a wireless router. And you can see why they would say that. They want to preempt the possibility of a defense that it was an open wireless network, anyone could just come on and surf on the signal and do all kinds of things. And the owner of the account would be blamed. So we asked Dr. Jacobson how he knew that there was no wireless network used by the defendant. Okay, so we asked him, he answers correctly. Does an IP address tell you if a device is wired or wireless? He says no. That's the correct answer. Let's see. Now we go down a few more pages, and here's his nonsense explanation. Now he says, when you say wireless router and then say no, how do you know there's no wireless? He says, again, by looking at Exhibit 6. Okay, Exhibit 6 is this this exhibit. It's just a long list of metadata. And I don't know how you can tell that this is not a wireless network by looking at this metadata of all these, MP3s. I don't see where it says not on a wireless network. I see some destination and source IP addresses, but it's just an IP address and a port, which, as you know from basic networking, you cannot find out if a device behind a router, how many devices there are, what kind of device it is. You just have the public internet address and a port. So here's this nonsensical explanation. Again, these are all public IP addresses on both the computer and the device that put the IP packet on the internet, both at the same IP. And if you can understand that, I mean, I'm hopeful that you can explain it to me and make sense of his kind of bullshit here. Now, as he was giving me this bullshit explanation at the deposition, he looks over to me nervously, and I noticed that he was trying to figure out if I was going to react in some way. So he has a really shitty poker face also. He knew he was lying when he said he could find out, he says he could determine if it's a wireless or a wired network. So he's a bad liar and a bad poker face. Let me see if I have any more things. Here's another, okay, this is my final thing, and I'll open up the floor to discussion. This is from Verizon. This is when the RIAA subpoenaed Verizon for their IP addresses and who was assigned this IP address. Now notice here, this is from their customer service tool. Now you see a whole bunch of problems here. You see a missing image. Okay, that's obviously something broken on their website. You see errors. You see different kinds of missing images here. And you also see something very interesting. Marie Lindor, Texas, 75038 as the zip code. Now that's Irving, Texas. Now this woman is a resident of Brooklyn. Now why they have a Texas address on here, that is just completely bizarre. And there's, in this test results, there's errors recorded, but there's no explanation for what they are, what they might be, and there's no attempts by the plaintiffs to verify this. I mean, this is the obvious red light when you have someone who is in Texas. That would make you sort of question the validity of this report. So these are just some of the crap that the record companies are presenting to the judges and saying, hey, this is evidence. This is what proves that this person was downloading or uploading files. But these companies have all this money and they can just throw documents at the judges and they'll buy it. They've been very hostile to us because we're defending people that don't have a lot of money, don't have a lot of resources, and so it's a big David and Goliath kind of thing where it's an uphill struggle. We can't even get Media Century to give us one bit of information about their investigation because basically I think it's just a whole bunch of smoke and mirrors. They really don't have a process that's reliable, that's scientific. It's just probably some guy that they're paying to get on Kazaa and just take screenshots and just take hundreds and hundreds of screenshots. But it's a black box. We don't know what their process is. We don't know how inaccurate it is. And from looking at some of these documents, they don't make any attempts to verify any of this data. There's no scientific credibility there. And I think I'll open it up to questions now. I'm sure you have a whole bunch.
So fire away if you want to know more about this. And for future research, can I have the video? My blog, it's Recording Industry versus the People. That's where you can read up on these documents. So, okay.
Hope is what, 26 years old?
What?
2600 is 26 years old. Hope is what, 18 years old, something like that? The reason why I ask is this. We all talk about these, I don't mean to be ageist, but we all talk about these quote-unquote older judges that quote-unquote don't know anything about technology. And we all know that's going to change relatively soon. Now, judges are not supposed to take kickbacks. So what are you guys', or anyone in the room, what are you guys' thoughts about how long it'll take before judges become a little bit more hip?
Judges are becoming more aware, and I think they were caught off guard. I have an article coming out in August in the Judges Journal of the American Bar Association, their publication for judges. I was invited to write this article for their equal access to justice issue. And it's evident that the judges are, in the first instance, they were caught off guard. They saw all these cases with big papers, big law firms. The defendants weren't represented. Most of the cases were ex parte cases where the defendants weren't even notified there was a case. When the defendants were finally sued, there were default judgments. There were people showing up without lawyers because there's no way they could afford a lawyer. So the judges were caught off guard. They had these big law firms, big papers, but it's evident that during the past year or two, they're starting to get wise. Not all of them, but more and more. The tide has turned, and they are going to lose. And it is now becoming, you have a judge who just conducted this highly publicized trial in Minnesota, and now has publicly humiliated himself by saying that he committed a manifest error of law. I've been in the litigation field for 34 years. I have never seen that happen before, never. So how do you think that judge feels knowing that he was misled by these lawyers? And when he wrote that decision, he didn't even know that he had been misled on something even more serious. Because the nature of his having been misled was the failure to bring to the judge's attention a controlling contrary authority that the other side should have briefed, but incompetently did not brief. Well, that's something that a lawyer, you might almost say, well, that's kind of a technical thing. That's one of those rules that's a little hard to live with, telling a judge that there's an authority against your client's position. It's required of us, but nobody really wants to do that. But they did something even more extreme that the judge didn't know about, which is that there was one of the two cases they were relying on had been reversed a week earlier. The judge in that case had vacated his decision, and they didn't tell the judge. They had an obligation to tell the judge, and they didn't. And the judge is going to be livid. The Duluth News Tribune asked me to write something, and I wrote something because there's an oral argument coming up on August 4th. And I said, I closed my article by saying, if you want to see a federal judge who's hopping mad, be in the Duluth Federal Courthouse on August 4th at 10 a.m. Okay, next question.
I'll make a comment first. I've noticed that even newer lawyers are not exactly what I'd call technically competent. I found the last comment I got from a fellow colleague was when I was using Ubuntu at work, he said, "That's illegal." Okay, snide comment aside, I'm a lawyer, I'm a techie, what can I do to help?
You're a lawyer and a techie?
Yep.
You could represent some of these people. So
I'll give you my card.
Okay, and join up. We have a directory of defense lawyers. I put people in there who I think will help fight for these people, and a lawyer with a technical background is especially priceless.
What can information security people and general counsel at the various ISPs do to combat subpoenas, DMCA takedown notices, and like the pre-litigation settlement letters that come in?
Well, the pre-litigation settlement letters have no legal standing whatsoever. And I think what I would like to see happen is I'd like to see, although there are many who say, well, they should just be dumped in the wastebasket or this or that. Personally, I think they're not that important. What I would like to see, I'd like to see you negotiate with the RIAA and say, listen, we'll pass these along for you.